Hey everyone, let's dive right into this explainer. If you're gearing up for your contract law essay exams, you already know that spotting the issue is only half the battle, right? The other half is handing the grader the precise rules they're looking for. So this explainer is designed specifically to give you the exact black-letter law rules and the exact phrasing you need to rack up those points. We're going to break down how a contractual duty matures, how it can be excused, and what legally happens when the whole thing just falls apart.
We'll be following the chronological life cycle of a contract through 5 stages. 1. Triggers, types of conditions. 2. Bending rules, waiver and estoppel. 3. Walking away, anticipatory repudiation. 4. Degrees of failure, breach. And 5. Acts of God, supervening events.
Section 1. Triggers, types of conditions. Okay, so before anyone can even be sued for breach, a legal duty has to actually be triggered. We start with the most explicit trigger out there, the express condition. You're going to spot these on an exam when the contract uses words like if, provided that, or subject to. Now, unlike general promises, an express condition demands absolute, strict compliance. If an express condition says delivery by 5 p.m. and delivery happens at 5:01 p.m., that duty to perform simply never matures. Close enough does not count here.
Law exams absolutely love to test the boundary between express and constructive conditions. While express conditions are written directly into the text by the parties and require that strict compliance we just talked about, constructive conditions are actually implied by the court. They're imposed by law just to ensure a structured, logical order of performance. Think of a classic everyday example. If I agree to sell you a $5 ice cream bar, the law implies a constructive condition of exchange. My delivery of that ice cream is a constructive condition of your duty to hand over the $5.
When we look at timing, the absolute most heavily tested condition is the condition precedent. I highly recommend you write this exact phrasing down for your IRAC rule blocks. A condition precedent is an uncertain event that must occur before a party's duty to perform becomes absolute. Simply put, if the condition precedent doesn't happen, the legal duty is discharged. The obligation is dead in the water.
And this brings us to another classic exam test, conditions of satisfaction. When a contract requires one party to literally be satisfied before paying up, what standard do we use? Well, objective satisfaction uses a reasonable person standard. Like, would a reasonable person find this commercial building up to code? Subjective satisfaction, on the other hand, relies on personal taste or aesthetics. Think of painting a family portrait. But keep in mind, subjective satisfaction isn't just a free pass to cancel a deal. It's strictly limited by the legal obligation of good faith.
Which leads us perfectly into the doctrine of wrongful prevention. You simply cannot purposely sabotage a condition just to escape a contract. If a buyer secretly calls the bank to sabotage their own financing just so they can back out of buying a house, they're acting in bad faith. If you do this, the court is going to step in and excuse the condition entirely, which means your duty to buy that house is now absolute.
Section 2. Bending rules, waiver and estoppel. So, what happens if a condition isn't met, but the parties decide to keep performing anyway? You've got to be able to contrast these two doctrines on a written essay. Waiver is the intentional relinquishment of a known right. It's basically saying, hey, I know you missed the deadline, but I'll accept the performance anyway. Estoppel, however, is all about detrimental reliance. Estoppel precludes a party from asserting a condition because the other party reasonably relied on a misrepresentation or conduct to their detriment. Essentially, waiver is about intent, while estoppel is about reliance and fairness.
The Burger King versus family dining case is just a phenomenal, real-world illustration of these concepts. Burger King had a territorial agreement that granted a franchisee 90 years of exclusivity provided they built 10 restaurants on a very strict timeline. Well, the franchisee opened several restaurants a few months late. Initially, Burger King didn't complain at all, but years later they suddenly tried to terminate the entire 90-year deal over a subsequent late opening.
The court actually stepped in here, citing Restatement Section 302. Because Burger King had essentially waived strict compliance early on by not demanding exact development timelines, the franchisee kept investing heavily in the territory. The court ruled that suddenly enforcing that strict condition after years of leniency would cause an extreme, unfair forfeiture to the franchisee. Basically, Burger King wasn't allowed to just pull the rug out from under them.
Section 3. Walking away, anticipatory repudiation.
Okay, we've talked about conditions that trigger performance. But what happens when someone backs out before they're even supposed to perform? This text right here from Restatement Section 250 is your golden rule text for anticipatory repudiation. The defining characteristic is that the repudiation must be absolute and unequivocal. It can't just be mere anxiety, worry, or doubt. Saying, "I'm kind of not sure if I can find the money," is not a repudiation. Saying, "I will definitely not pay you next Tuesday," absolutely is.
When that absolute, unequivocal announcement is made, it radically shifts the entire legal landscape. Upon receiving this clear signal, the non-breaching party's duties are instantly excused. I mean, think about it. They don't have to keep preparing to perform for someone who has already flat out admitted they're going to breach.
When you're facing a repudiation, the injured party actually has a specific toolkit. First off, you can sue immediately. You literally don't have to wait for the actual performance date. Second, you can wait and urge them to perform, just hoping they change their mind. And third, and guys, this is a massive issue spotter on exams, if they merely express doubt and don't unequivocally repudiate, you can demand written adequate assurances. Under the Uniform Commercial Code, they have exactly 30 days to provide those assurances. If they fail to do it, their silence legally transforms into a total repudiation.
Section 4. Degrees of failure, breach.
All right, so performance was officially due, the conditions were met, no one repudiated early, but the performance ultimately failed anyway. We are now officially in the territory of breach. But on an exam, you have to make a critical distinction here. Not all breaches are created equal. A minor breach means a party substantially performed their end of the bargain. And if you get substantial performance, the contract survives. The non-breaching party still has to perform, though. They can totally deduct damages for the minor flaw. A material breach, however, completely destroys the constructive condition of exchange. If the breach is material, the non-breaching party can just cancel the contract and walk away.
If you spot a breach, you have to immediately consider the remedies. And please remember to drop the doctrine of mitigation, also known as avoidable consequences, into your damages analysis. The law absolutely hates economic waste. You can't just sit back and let financial losses rack up if you could have reasonably prevented them. If a tenant breaks a lease, the landlord actually has to try to find a new tenant. They can't just leave the apartment empty and sue for a whole year's rent.
Section 5. Acts of God, supervening events.
What if a breach really isn't anyone's fault? We're talking about the ultimate escape hatches that legally forgive a failure to perform due to massive, unforeseeable disruptions. You need to lock this three-part checklist from Restatement Section 261 into your memory right now. For both impossibility and impracticality, you need an unforeseeable event, the non-occurrence of which was a basic assumption of the contract, and the party seeking the excuse cannot be at fault. The difference is really just a matter of degree. Impracticality means the event made performance excessively burdensome, commercially unreasonable, or massively costly. Impossibility is way stricter. It means performance physically cannot be done by anyone at all, like the concert hall literally burned down to the ground.
Finally, we have frustration of purpose, which rounds out our discharge by supervening event. This is kind of the cousin to impossibility. Here, performance is still perfectly physically possible, but the whole commercial meaning of the transaction has been totally destroyed by something out of your control. Imagine you rent a balcony at a premium price specifically to watch a king's coronation parade, and the parade is suddenly canceled because the king falls ill. You can technically still stand on the balcony, but your principal purpose is totally frustrated, so your duty to pay is legally discharged.
So what happens when your examiner throws a massive factual curveball? Step back and use this timeline. Ask yourself, was an express condition so strict that duty never even formed based on the creation of duty rule from Paradigm versus Jane? Did a supervening event discharge the duty entirely? Memorize these triggers, but always look ahead. Once a material breach is confirmed, how do you actually allocate the risk of loss? Do you apply the standard contract remedy of expectation damages? If someone is fired, does the alternative employment standard apply, or does the different or inferior kind exception save them? Can a lost volume seller recover more under the UCC, or do liquidated damages just act as an illegal penalty? What about emotional distress limitations or construction and property repair damages, measuring cost of performance versus diminution in value? And don't forget punitive damages exclusions, or the American rule for attorney's fees. Master this timeline first, and you'll be perfectly positioned to tackle that complex world of remedies next. Keep explaining the law clearly, and you're going to crush it.